Good afternoon, everyone. I will hereby convene this meeting of the Government Administration and Elections Committee. Are there any remarks from my co-chair? Remarks from the rankings? Seeing none, we will move on to item number 3 of our agenda, bills and resolutions for final action. The first item on our agenda is Senate Bill 1163, an act concerning qualifications of individuals appointed to serve as moderators at elections and primaries. This will be a JFS to the floor, LCO number 6709. I will entertain a motion. Moved by Senator Flexer, seconded by Representative Osborne. Is there, well, I will say what this bill does. It will specify that registrars may not appoint moderators who have been convicted of or pled guilty to election law offenses or certain felonies. Is there further comment on this bill? Senator Sampson.
Thank you very much, Mr. Chairman. I appreciate your description of the bill based on the substitute language, because I know it was a bit of a departure from the original bill. I mean, same kind of intent, but really a significant change from what the underlying bill was. It sounds very reasonable to me. I'm surprised we don't already have requirements like this. So this is a very good policy, and I wholeheartedly endorse it, and I will vote yes. Thank you.
Thank you, Senator. Further comment on the bill? If not, Mr. Clerk, will you please call the roll?
This is a roll call vote on item number 1, Senate Bill 1163, an act concerning qualifications of individuals appointed to serve as moderators at elections and primaries. The motion is to JFS LCO 6709 to the floor. Senator Flexer.
Senator Flexer votes yes.
Representative Blumenthal. Senator Honig. Representative Warren-Bello. Representative Osborne.
Osborne votes yes.
Senator Sampson.
Sampson is yes.
Representative Master-Francesco.
Yes.
Representative Bronco. Representative Carpino. Representative Fonsello. Representative Gauthier.
Gauthier, yes.
Representative Haddad. Representative Hoxa.
Hoxa is yes.
Representative Johnson.
Representative Johnson votes yes.
Representative Menapace.
Yes.
Representative Rosario. Representative Santiago.
Yes.
Representative Shannon.
Shannon votes yes.
Senator Winfield. Thank you, Mr. Chair.
Thank you, Mr. Clerk. Next up on our agenda, and one moment, please. Okay, and we will be holding votes open on all these bills until no earlier than 5 p.m. With a time to be announced at the end before we recess. Next up on our agenda, we have item number 2, Senate Bill 1168, an act providing a safeguard to contributors on online political fundraising platforms related to automatically recurring contributions. This is the JFS to the floor of LCO number 6712. Chair will entertain a motion.
So moved.
Moved by Senator Flexer, seconded by Representative Haddad. This bill does 2 things. It specifies that an online platform that collects contributions may not allow for automatically recurring contributions from a contributor without their affirmative consent. Allowing them to uncheck a box is not good enough, and this is an anti-fraud and consumer protection provision. Additionally, it amends our state campaign finance laws definition of contribution and expenditure to exclude certain voluntary payments made to certain online political platforms. And this is to allow for political donations online through established platforms. Is there further comment on this bill? Senator Sampson.
Thank you very much, Mr. Chairman. Yeah, so again, this is another substitute bill, and I had it in my mind to support this item with the original language, which is what is currently just section 3. Because I agree with your assessment that, you know, the notion of just unchecking a box that would allow for recurring contributions is not satisfactory. And I do think it's a good provision, and I'd like to see that part continue, and would certainly support it on its own. I am struggling, however, with the addition of sections 1 and 2. And I guess my concern is this would allow an online platform to effectively accept a contribution for a political campaign, for example, but also pay an additional amount. Is that correct through you?
Not 100%. I'll just kind of clarify in a response, and then you can tell me if I addressed your question properly. So there are certain online platforms that collect political donations on behalf of parties or candidates or committees. And they also, in order to support their own operations, not to benefit any committee or candidate or cause, collect essentially a tip or a side donation that helps fund their own operations. And under our current law, it's not clear that someone in Connecticut can donate through one of those platforms. So it wouldn't be an additional contribution to any candidate, cause, or committee, but it would be, I guess, essentially a contribution to the platform itself to fund its operations only. To you.
Thank you very much, Mr. Chairman. I appreciate the clarification. I think you basically said what I said, which is that the person could be making a payment, a contribution to a campaign, but then also add an additional amount, a voluntary additional payment that would not be a contribution to that candidate, but it would go to the platform itself. And according to the language that is in both sections 1 and 2, it's the same language. It says, used by such online platform to conduct its operations. And I guess this is where I have some concern. Is this the term operations specified anywhere to make it absolutely, clear that this money cannot be used for any other political purpose, for example, through you?
It does not specify the exact definition of operations, but I believe it would be a plain language definition. And the fact that it says operations right next to contribution specifies that it cannot be used for the purposes of a contribution. Certainly, if it is not 100% clear, that's something that we could discuss going forward.
Okay, I just,
To you.
yeah, thank you. I was just waiting on you. So, Mr. Chairman, I appreciate that. And again, I'm sympathetic to it. And if that is indeed the intent here, that we're going to very, very specifically limit the online platform to make sure that that money cannot be used for another purpose. Because this is kind of my concern about some of these bills that we've had in the past. You know, people refer to them as the Act Blue bills, partly because of some of their activities around our country that have been in the news a lot, which effectively what they're doing is they're using their platform as a mechanism to collect additional funds, which can be used for other purposes. They can either use those funds to help other candidates or to raise awareness about other candidates, or they can use them for political advocacy for themselves. And that's what I'm trying to avoid. And I guess, I get that the language in the bill is about operations, but we all know that money is fungible to a degree. So that if I assume that they collect a fee from the candidate or campaign that they are working for when they receive the contribution and they run their operation from those proceeds. I mean, we use in Connecticut, a lot of candidates in both parties use Antidote, and they charge a percentage much like a credit card company, which would charge a percentage for processing the fee. And that's how they run their operations. I assume that that's going to continue to apply. So this is just additional money over and above what they're already using to run their operations. And because it's kind of vague, in the sense that, you know, even if they did decide to use this money to fund their operations, what prohibits them from having additional resources because they don't have more money in their pocket now to use the other money they used to run their operations to engage in political advocacy? Maybe I'm you know, trying to, you know, create a conspiracy out of this, but I have a concern, especially with the way that we are very, very careful about our citizens election program, for example, and our state campaign finance laws, which are very, very specific about who is a contributor, you know, what a campaign is, in-kind contributions. You know, that's what concerns me more than anything about this particular language. I'll listen to the rest of the conversation and maybe I could be convinced. Or, you know, if I have your assurance going forward that we're going to tighten this up to make sure that it's absolutely clear that this is not intended to allow them to use it for anything other than the operation of their platform and not for a political purpose, I could maybe come around to supporting it. Thank you.
Thank you, Senator. Further comment on this bill? Representative Massa Francesca.
Thank you, Mr. Chairman. So Section 3 of this bill with the original bill, I'm going to agree with Senator Sampson, is I actually really like that part of the section, that section of the bill. I think there's a lot of campaign donations that people make that don't realize that they need to uncheck a box, or they will have recurring payments to that campaign. And I think that's a good thing that was cleaned up here, that it would be no longer allowed. So I really like that section of the bill. Again, it is sections 1 and 2 that obviously I have the issue with. So, Mr. Chairman, can you tell me right now in Connecticut, I guess there's Act Blue, there's WinRed, and then we have Anadot, right? Is it that the state of Connecticut, our policy or our statutes do not allow for these online platforms to do what is intended in this bill, and then that whatever is in this, the language in this bill will allow them to do business in Connecticut on a state level? I don't know if it has something to do with state contributions and federal contributions. Can you kind of explain that?
To you, Representative, to answer your question to the best of my ability, I think there's some other campaign services or online donation platforms as well, but most of these online donation platforms charge a set fee or percentage. Some others, instead of doing that, will ask for a voluntary donation. And there's some ambiguity in our law about whether that donation, again, to the platform for its operations, not as a political contribution, counts as a contribution under our law. And so over the past several years, we have worked with the State Elections Enforcement Commission to come up with language that would allow, again, a voluntary contribution to the platform itself, not for political purposes, as a funding mechanism so that all of the available online platforms can operate in the state without creating a situation where this would be a loophole that would be exploited to bypass our campaign finance laws. And so we came to a solution where the State Elections Enforcement Commission has signed off on this language to say that it does not create that concern for them. And that's the intent of this bill, is to allow the full spectrum of online donation, political online donation platforms to work in the state without creating a loophole that would bypass any of our campaign finance laws. To you.
Thank you. Okay, so I understand that. So how would one know if they were making an additional donation where that money was going to? It's for their operation. Like Senator Sampson, there's no real definition of operation. But at the end of the day, most of these organizations, Act Blue, WinRed, they are political organizations, right? They support one party or another. They're just moving money around. It's kind of like here when we just passed a bill for giving these nonprofits extra money, and they know they can't use it for a certain thing. Well, they're just shuffling money around. And it seems to be the same in this position, this particular case, because it doesn't define what their operations are. And no one would ever know what they're really using the money for. It's just extra money. They're just taking it out of one account and putting it in this account because they can't use it for that. So that's where my concern is. So currently, should this bill pass, it would allow them to do that. It would allow the contributions to go forward. The donate, the extra tip, I guess we'll call it, right? A tip. It would allow that to go forward because right now they cannot do that in Connecticut.
Correct. Right now, they cannot operate in the state of Connecticut under their system where they collect a voluntary tip or donation to their platform for the purposes of operating their platform in addition to and separately from the contribution. So they would be allowed to do that if they were to use the money for purposes or other purposes other than their operation. They would be in violation of our law too.
Thank you for that. So my next question is why? Why do we have to allow them to collect a tip? What's the purpose to you?
To you, Representative, to allow people to make political contributions through their preferred online donation platform.
Thank you. And I understand that, but they're making a contribution or a donation to a candidate. And then in addition, they're adding a tip on top of that. If they wanted to support their organization, I would assume they can just mail them a check or go do a separate, go to their website, donate to our cause and make a donation there and bypassing a candidate contribution at the same transaction. Is that correct?
I suppose there is nothing stopping them from doing so, but I think probably the practical distinction is that most of these online donation platforms operate in multiple states, and most of them in all 49 states other than Connecticut.
Right.
And it would be very difficult for them to discriminate state by state about what, how the platform should look when you access it. So I think the idea is basically, right now, Connecticut candidates and Connecticut contributors can't really use some of these platforms in state races. This would allow them to do so as long as whatever that voluntary donation or tip is separate from the contribution and is used only for the operations of the platform.
Okay, thank you. So I would just say that there is a mechanism for people to make a donation to these online platforms for their operations. Like any other business, they have a website. Donate to us so we can continue being in business. Support our cause, and people can go online and make a donation as opposed to going through a person who's already donating to a campaign. So again, I like Section 3. I fully support that, but I have a lot of concerns about these first two sections. I'll be a no today on this, Mr. Chairman. Thank you.
Thank you, Representative. Further comment on this bill? Seeing none? Seeing none, Mr. Clerk, would you please call the roll?
This is a roll call vote on item number 2, Senate Bill 1168, an act providing a safeguard to contributors on online political fundraising platforms related to automatically recurring contributions. The motion is to JFS LCO 6712 to the floor. Senator Flexer,
Yes.
Representative Blumenthal,
Yes.
Senator Honig,
Yes.
Representative Morin-Bello,
Yes.
Representative Osborne,
Yes.
Senator Sampson, Representative Master Francesco,
No.
Representative Bronco, Representative Carpino, Representative Fonsello, Representative Gauthier,
Yes.
Representative Haddad, Representative Hoxa,
Rep. Hoxa votes yes.
Representative Johnson,
Representative Johnson votes yes.
Representative Menapace,
Yes.
Representative Rosario, Representative Santiago,
Yes.
Representative Shannon,
Shannon votes yes.
Senator Winfield. And I didn't catch your vote, Senator Sampson.
Sampson is no. Thank you.
Thank you. Thank you, Mr. Chair.
Thank you, Mr. Clerk. Next up on our agenda, we have item number 3, Senate Bill 1499, an act implementing the recommendations of the State Contracting Standards Board. This is a straight draft to the floor. Chair will entertain a motion. Do we have a second?
Second.
Moved by Senator Flexer, seconded by Senator Honig. This bill would provide a number of measures to increase the independence of the State Contracting Standards Board, including protecting its budget requests from modification before they're submitted to the legislature. It would expand the board's authority with regard to quasi-public agencies and mandate certain additional notices and disclosures. Is there further comment on this bill? Sorry, Representative Master Francesco.
Thank you, Mr. Chairman. This is quite a lengthy bill. I heard the testimony on it. There's probably some decent things in here that are okay and acceptable that I'm okay with. But there's one piece in here that I totally disagree with. And it's the section in there where, and I don't know, can't tell you what line it's on. Whoops, that's me, sorry. And I heard the testimony on this where they submit their budget to the governor, and there's a section in here that does not allow the governor to reduce that allotment amount. Is that correct? To you, Mr. Chairman?
I'll try to answer your question, and if I miss anything, Senator Flexer will fill us in. So, Representative, to you, my understanding of the bill is essentially that under current law, the board may submit a proposed budget or budgetary request to the governor, but the governor can then change those before those requests are submitted to the legislature. And so we in the General Assembly may never get to see what the board actually thinks its budgetary requirements are. That's a particular concern in a situation like this one, where the board is a watchdog agency that oversees contracts made by the executive branch. And so I believe it's section 1 that contains this language. This would mandate that the requests be submitted straight to the General Assembly, where we would make a decision alongside the governor in the budgetary process about what the board should get. But it wouldn't be that the board can submit what it thinks are its requirements to the governor says, I don't think so, and then we never see them to you. And Senator Flexer will add on.
Thank you. Thank you, Mr. Chair. And to the good representative, I just want to emphasize that this provision actually replicates existing statute for other watchdog agencies where their budget proposals do get sent directly to the legislature, so that we can look at it in its totality. And I think it's good public policy because, as you won't be surprised to hear, there's often a lot of give and take between an executive branch and the agencies that serve as watchdogs over their activities. And so I think it's important for this body, just like many other watchdog agencies, to have this fiscal independence, and that the legislature can see the fullness of what their budget requests are, especially given the history of this body, right? It took more than a decade for the Contracting Standards Board to be fully staffed and fully operational. Clearly, there has long been a tension through multiple administrations between this board and the executive branch. So I think it clearly that history clearly demonstrates why its budget proposal should be independently put forward to the legislature for our full review. Thank you, Mr. Chair.
Thank you, Senator. Back to you,
Thank you.
Representative.
Thank you. So, is it not the authority of the executive branch to propose a budget? And other departments, I'm assuming he approves, or he may modify what their budgets are. You mentioned that there's other agencies that do the same thing. Can you tell me which ones they are?
Senator Fluxer.
Thank you. Through you, Mr. Chair, I believe it's all the agencies that fall under the Office of Governmental Accountability, but I'm going to look that up for you. But it would be agencies like the State Elections Enforcement Commission, for example, the Office of State Ethics. I believe that their proposals, because they're watchdog agencies, don't get modified by the governor's budget office. Through you, Mr. Chair.
Thank you for that. I appreciate it. So it just raises a concern to me because it is the executive branch's duty to obviously put a budget together. I don't see how they can dictate what their budget will be. I mean, goes to the executive branch now. If the governor feels that that agency should be getting, maybe should adjust their budget, whether it's higher or lower, he has a right to do that. I may not agree with it, but he has a right to do that based on the laws now with his power of the executive branch. And putting it in the hands of the legislature, we do have appropriations committee. I get that. And we come up with a budget here all the time. But the governor also comes up with his budget. So when you take that authority away from the governors, the executive branch, not to come back and say, look, we can't afford it. I'm going to adjust your budget this month, this much. And then it would still come back to the legislature. Am I correct? It would, he may reduce that budget, but it still has to come back to this body for approval. Am I correct? Through you.
Senator Fluxer.
Thank you, Mr. Chair. So I think what we're talking about is two different steps in the budgetary process. So, and the part of the budget process that we don't see is when the executive branch is poring over the budget proposals they get from various agencies across state government. That traditionally happens in the fall and the winter, to my understanding. And what we're asking for in this language here, which by the way is the same language I believe that's been in this bill a few times in the past that this committee's looked at it, is to make sure that whatever that number was that was given in the fall is submitted to the legislature. So I can hear your point about the executive branch being able to make decisions on the funding levels for various agencies, that's part of their process in putting forward a budget. I would argue to you that there are some agencies that find themselves from time to time, and some of these agencies frequently, in conflict with an executive branch that they're in charge of guarding over, frankly. And so that's why I think making sure that whatever that dollar figure is that this particular agency says, this is how much we need to fully operate and serve out the statutory functions that you, the legislature, have given us to watch over the contracting process in our state. This is what we need to do our job. I think that's a figure that this legislature should be able to see. As someone who serves on the Appropriations Committee, sometimes it can be hard to get straight budget numbers out of agencies when the executive branch is particularly limiting how much information they can share. We don't want to see a contracting standards board that has to live in that gray area where they're being pushed by an executive branch that wants to limit how much funding they have, perhaps in an effort to limit their functionality. Thank you, Mr. Chair.
Thank you, Senator. Representative.
Thank you. Thank you, Mr. Chairman. Thank you, Senator. So listen, I totally am in agreement with you on some of this. I'm just really stuck on taking that authority away from the executive branch because they are doing it round. The governor is running the state. He puts his budget together. It's that part of the bill, I got to be honest with you, is a concern. The rest of it is fine. I do believe that department still comes back to the legislature, that agency, and it could be adjusted on this end. I don't understand why we're making this change, to be quite honest with you. It just doesn't make any sense to me. So I'm hesitant today. I'm going to vote no on this today and see what happens should it come to the floor. And perhaps something will change my mind. Thank you, Madam Chair.
Thank you, Representative. Senator Fluxer.
Thank you, Mr. Chair. In an effort to change minds, I just want to add that I want members of this committee to reflect on, if they're willing, to how long it took from this legislature before I think any member of this committee looking around the circle was even elected to this body. The Contracting Standards Board was formed. And it wasn't until the last 2 years that we had a fully functioning agency that could actually do its job. So on paper, for more than a decade, Connecticut had laws governing state contracting and a board that was supposed to review that process. And it took years of fighting with different people who occupied the executive branch. It took years of fighting to finally get a fully functioning contracting standards board to be able to perform these important watchdog functions. So, and I do just want to emphasize again that there are a number of other watchdog agencies that already have their budget proposals protected in a way that's very similar to the proposal that's outlined here. So it's not creating something new. It is just modeling the existing statutory protections to the budgets for other watchdog agencies here in the state of Connecticut. Thank you, Mr. Chair.
Thank you, Madam Co-Chair. Further comment on this bill, Senator Sampson.
Thank you very much, Mr. Chairman. Yeah, so as was mentioned, this is a 43-page document, and it's a little tricky to understand all of the changes because sometimes they're just appear very minor changes to the existing statute, but you've got to go down a few rabbit holes to find out exactly what those minor few words mean. And I just want to ask a question. So this bill was before us in a similar or exactly the same form last year. And in 2024, it was Senate Bill 391. And I remember that we passed it on party lines out of this committee last time, and I presume that the Republicans were voting no. And later on, the bill, when it came before the Senate, it was modified in some way, and it passed unanimously. I'm trying to recall exactly what that change was, and I'm curious to know whether or not the bill that is before us reflects Senate Bill 391 as we voted it out of committee last time, or it's the bill that we passed unanimously in the Senate, or it's something else entirely. Through you.
As someone who is not a member of that August body, I'm going to leave that to my co-chair.
Thank you, Mr. Chair. As someone who has passionately advocated for this bill for a number of years and has been very grateful for the bipartisan support it's received in the past. If memory serves me correctly, and please don't hold me to this, but I believe the reason why some members of this committee voted no of this almost identical proposal last year was because it covered the quasi-public agencies. I don't want to put words in the previous members' mouths, but I think that's what the objection was, were some concerns from quasi-public agencies. And the bill that passed the Senate unanimously removed the language that covered the quasi-public agencies with oversight for the Contracting Standards Board. Thank you, Mr. Chair.
Thank you very much, Mr. Chairman and Madam Chairman, for that response. So I don't think that was it, frankly, because I would have gladly supported the oversight for the quasis. And I do know that in previous years, this bill, again, I know has been around for a number of years. I know that we worked together to try and get something like this passed. And I know how it goes, which is that over time, the various quasi agencies in the state decide to make their feelings known to the leadership, and we're carving out this group, and then we're carving out that group, and before you know it, there's nothing left of the bill. So I mean that's not my issue. I'm with you. I like very much the significant level of oversight that we're trying to make sure the Contracting Standards Board has. So I am there. There are certain aspects of the language of the bill that I have some concerns with. I don't mean to disagree with my ranking member colleague, but I believe sincerely that I think that the watchdog agencies should submit their budget proposal to the legislature unadulterated by the executive branch, because in fact they are overseeing the executive branch. And it makes little sense for the executive branch to be able to say, no, we're gonna cut you if you do that. I do want to ask about this section. I don't know what section of the bill it is. It's lines 557 through 563, I believe. And this is, appears to be regarding business cases that are developed by any state contracting agency, and what kind of information they have to provide. And it reads that they have to provide an analysis of the potential impact of their proposed privatization contract on workers of color and workers who are women, including whether such privatization contract will lessen or increase historical patterns that produce inequities between such workers and other workers. Anyone who hears me in this committee or anywhere else understands that I don't go for DEI type policy. I want people judged purely on merit. I understand all the arguments for historical discrimination and so forth, and they're certainly legitimate, but I don't believe that this mechanism to correct it is by perpetuating different types of discrimination. So I'm curious what this addition of this language, what the purpose of it is here. Is it to, as often described by some folks that engage in that type of policy advocacy? Is it to right the wrongs of the past, or is it simply to prevent any type of discrimination and only honor a merit-based system? Through you.
To you, Senator, my understanding of the intent, and based on the language, I think this echoes it, is to address any impacts in the future to workers of color, workers who are women, or historical patterns. So it would be what happens in the future based on the privatization contract. And so it doesn't mandate any particular result, but instead mandates that issue be examined as part of the business case. And it also would, if we follow the language down to 599 of the bill, it would also mandate that the business case also include how the privatization would affect the provision of essential human services to the residents of the state who would otherwise lack the support necessary to assure basic human needs. So this would increase and aim to prevent discrimination or negative effects to individuals based on those categories. To you.
Thank you very much, Mr. Chairman. I appreciate the additional information, and I appreciate your interpretation of the language that is before us. For me, I think it's pretty clear that the purpose of collecting this information is to perpetuate a system where we are, in fact, making hiring and contract choices based on those aspects of color and gender. And it's a frustration I have. I would like this to get away from that and stick to merit, as I said. As far as the language of the bill, I think I'm comfortable with what the rest of what I've seen. But like my colleague, I'm going to vote no today in the sense that I think there's a lot here. And while I'm certainly an advocate for increasing the oversight of the quasi-publics and state government in general, including the executive branch, I think, what's happening on a national level teaches us that there's a lot of waste and fraud and in government, and sometimes you have to trim back the state. And so I'm certainly an advocate for policies like this, but because of that language being included in here, I'm going to hesitate for now. Hopefully we can work on this together and maybe come up with a compromise. Thank you very much, Mr. Chairman.
Thank you, Senator. And just to amplify my previous answer to his question, that section of the bill has been in the previous iterations that we've seen over the past couple years. Not sure if it affects his decision in any way today, but just for the committee's reference and for our understanding going forward. Is there further comment from the committee? Seeing none, Mr. Clerk, would you please call the roll?
This is a roll call vote for item number 3, Senate Bill 1499, an act implementing the recommendations of the State Contracting Standards Board. The motion is to JF to the floor. Senator Flexer,
Yes.
Representative Blumenthal,
Yes.
Yes.
oh, it's all good. Representative Morambello,
Yes.
Representative Osborne,
Yes.
Senator Sampson,
Sampson is no.
Representative Master Francesco,
No.
Representative Bronco, Representative Carpino, Representative Fonsello, Representative Gauthier,
Yes.
Representative Haddad, Representative Hoxa, Representative Johnson,
Representative Johnson votes yes.
Representative Menapace,
Yes.
Representative Rosario, Representative Santiago,
yes,
Representative Shannon,
Shannon votes yes.
Senator Winfield. Thank you, Mr. Chair.
Thank you, Mr. Clerk. On to item number 4, SJ 36, a resolution proposing a state constitutional amendment concerning environmental rights. This is a JFS to the floor of LCO number 6720. The chair will entertain a motion.
So moved.
Moved by Senator Flexer, seconded by Representative Moore Imbello. This would create a state constitutional right to clean air, water, and laws preventing the damage from the effects of climate change and to preserve a clean environment for this state based on the current status of the Connecticut Environmental Policy Act. Is there further comment on this resolution? Senator Sampson.
Thank you very much for the recognition, Mr. Chairman. Can you just start by describing for me how this bill has changed with the substitute language?
So the JFS language to you, the JFS language eliminates references to traditionally marginalized groups. It adds a reasonability standard for state infringement and protection of these rights and responsibilities for avoiding environmental harm. Specifies the state must seek to meet its responsibilities instead of being required to, and it eliminates a prohibition on diverting any funds for supporting the protection of the state's natural resources to you.
Thank you very much for that clarification. I have a lot of questions and concerns and comments on this proposal, but I want to start by making it abundantly clear that, you know, any appearance that folks that do not support this are not in favor of a clean environment or protecting the earth for future generations is misplaced, because we're all concerned with that. It's just a matter of debating the best public policy to achieve that end. And I have some significant concerns I'm going to point out with the way this policy will work and what the net result will be, and not the notion of how we should have a cleaner planet, which I certainly support. The first thing I want to just address is that the first line of the actual change, which appears on line 7, will change the section 21 of the, create the section 21 of our Constitution, reads, each person shall have an additional right. And it goes on to say to clean and healthy air and so on. Is there any other provision in our state constitution, Mr. Chairman, this is a sincere question, I didn't look it up, that says that each person shall have an individual right? In other words, where the state government, via an amendment to the Constitution, is creating a right for citizens.
To you, I believe there are a number of other provisions of the Constitution that recognize individual rights. I believe the right to education is specifically acknowledged as an individual one, but the declaration of, this provision would be Article 21 of Article 1st of our state constitution, which is titled the Declaration of Rights. And so I think it is understood. And if I look through these sections, it would be pretty clear that these are all maintaining individual rights, including equality before the law, the exercise and enjoyment of religious profession and worship without discrimination, the right to free speech, the right to a jury, a trial by jury, the right to be free of quartering soldiers. These are rights that adhere to the individuals of this state. To you.
Mr. Chairman, I appreciate the information, but that's not my question. My question is whether or not there is anything in the state constitution establishing rights. And I'll just use an example as the Bill of Rights in our U.S. Constitution. It's very clear, if you read each of the amendments, that there is an inherent understanding that rights come from a creator, or that they are at least natural rights. And you can dispute where they come from. But the fact is that what our Constitution says is that the government shall not infringe upon rights that pre-exist based on natural rights or their creation. And so just an example, I mean, the First Amendment to the Constitution says Congress shall make no law respecting an establishment of religion and so on. It's acknowledging that you have that inherently based on natural rights, and that the government is restricted from interfering with them. It goes on in the Second Amendment, third, fourth, the right of the people to be secure in their persons shall not be violated, for example. So that is the way we have structured our system of laws in the past. So it's very unusual in my mind to see a constitutional amendment that establishes a right. Even the recognition of education as a right in our state constitution, I don't know that it says that. I think it's very clear that it is not, it is more of an entitlement that is guaranteed by the state, as opposed to being a right that's natural and protected by the state government. So it's just an interesting question. If we don't have to continue on this very far, unless you have a good example to provide. Thank you.
Thank you, Senator. I believe and I agree that we could have a long debate about the nature and source of rights and whether they pre-exist our state constitution, which in its original form pre-existed as the fundamental orders, pre-existed the U.S. Constitution. But in its current form, there are a number of individual rights that are listed very specifically. We were a bit more explicit in our state constitution than the framers were in the U.S. Constitution about the natures of these individual rights and who they attain to. And so if we look to Article 1, the Declaration of Rights, I believe that those rights are declared for individuals there, whether they pre-exist the state constitution is a debate perhaps for another forum. To you.
Thank you very much, Mr. Chairman. And maybe after session, we can have that conversation somewhere and dig deep into where rights come from. I think an understanding of our American history it begs us to understand that rights do pre-exist any form of government, and that our founding documents as a nation point to the fact that our government exists to protect rights that are natural and inherent, and that pre-exist any written documents. And the reason why we have a Constitution and a Bill of Rights, at least on a national level, is to guarantee those rights and prohibit the government from interfering with them. I'm often frustrated, when we have bill proposals that create, what's the term that people use all the time? Language that allows something to happen. And I'm always pointing out that you don't need language for that. If it's not prohibited by law, it's already lawful. We have freedom to do what we choose to do in our society, and the government only has the ability to restrict those freedoms, not to create new ones. That's why I kind of wanted to raise that objection first, that I don't believe the government has the right to create rights. I'll also point out that, people say all the time, well, healthcare is a right, or housing is a right. And, while people should have housing and healthcare, I think it's difficult to classify those things as rights, because effectively to have healthcare, you require the work of another person, which is something I think we would all agree you do not have a right to. Whereas your right to speech, your right to life, your right to liberty can easily be recognized as things that we're born with and should be protected. So I just want to leave that there for a second and move on to some of the concerns I have with the bill. The first and foremost concern I have is just getting into the language, because I think that this bill is written in a very, very vague set of terms. And, when we've debated this in the past, the concern has always been the same conversation, which is it's vague. It's going to lead to a flood of frivolous lawsuits. And my number one issue with that is that when you have vagueness written into a law, let alone a constitutional amendment, what you're doing essentially is you're inviting another party to define it for you. And this confuses me because I always wonder when we here in the state legislature write policy that transfers our ability to make decisions to someone else. Like whether or not we write a policy that says we're going to empower some state agency to create regulations. Or in this particular case, I think we're leaving the decisions of what is considered to be a stable climate or what's unreasonably infringing on something up to a court. And, the way we make policy right now is through a representative system of government, which is our constituents come to us and we bring their concerns, thoughts, ideas, and desires to the legislature, and we communicate with one another in a way that allows us to come up with public policy. If we are so vague in the public policy that we create that it ends up being thrown into a court and potentially one person is going to be the decider of what's unreasonable or what's reasonable or what a stable climate is, I think we're failing as a legislature. I also think we're failing the people that we represent. Laws, number one, should be clear. They should be easy to understand, and they should apply to everyone equally. And whenever you have a law that is not clear, there's actually a term. I not being a lawyer, but I'm sure that the good chairman will recognize this term, void for vagueness. This is something that happens in court sometimes when they see a law that cannot be clearly understood. And I'm afraid that that's what's going on here. Can I just ask right out of the gate on line 9, what is a stable climate?
To you, Senator, is a climate that is not changed in a manner that is dangerous or deleterious to the health and environment of this state. And it would be interpreted in light of the law developed implementing the Connecticut Environmental Policy Act. To you.
Thank you very much. I'm glad you mentioned the policy of the state that already exists. And I think that we can talk about that as well. But your definition of a stable climate, I don't think applies to our climate currently. I mean, the climate in here seems pretty stable. I mean, there's a thermostat and a heating and cooling system that's keeping it comfortable. But if you walk outdoors, at 1 a.m. tomorrow, it's going to be a little chilly. The climate is changing on the hour, on the minute, across our state, across our country. And I don't know that you would call that stable, even from a day-to-day perspective, let alone over a period of time. So am I to understand that this term stable climate, it also says safe and stable climate. Is it a safe and stable climate on February 2nd of this year when it was, several degrees below zero in my hometown? Mr. Chairman?
To you, Senator, I don't believe it would be based on any particular day. I think the term is addressed to long-term climate and would be interpreted in accordance with the Connecticut Environmental Policy Act, which has developed a number of standards for what is reasonable with regard to state action or other matters. And I would just point out that this is a constitutional amendment that would bind the state and what its efforts are to address those issues, not to whether the issues exist at all to you.
Thank you very much, Mr. Chairman. Again, I don't dispute anything that you said, except for the fact that the ultimate decision about what will be a stable climate is not being determined in our amendment. And neither is what is the state not unreasonably infringing upon the right that you have just created for someone to have a stable and safe climate. So that's just an example of where I believe this policy goes off the rails. You know, we already have a state statute. It's section 22A-1. It's the policy of the state. And it says that the General Assembly hereby declares that the policy of the state of Connecticut is to conserve, improve, and protect its natural resources and environment, and to control air, land, and water pollution in order to enhance the health, safety, and welfare of the people of the state. I wholeheartedly agree with that. That is our mission as a legislature, to make policy. We have an environment committee in this building. We have an energy committee. We have our committee. All of those committees are working to make policy for the state. And presumably they are bound by this requirement that we have already put in statute about our mission. So when we're making policy, we're keeping in mind what it means to try and create a safe environment for the citizens and the future citizens of Connecticut. And I wholeheartedly back that 100%. But to create a constitutional amendment only does one thing that's different than that policy. That policy means we're already working towards that end. But putting it in the Constitution does only one thing, and that creates a cause of action in case someone believes that their right that is established in this amendment is violated. Is there a desire, Mr. Chairman, to create lawsuits against the state of Connecticut?
To you, Senator, I believe under the Connecticut Environmental Policy Act, there are opportunities for private causes of action related to issues that are being decided. So I don't think that's necessarily a change. I think the change is that that policy and those policies embodied in that statute are, again, statutory in nature. So they could be changed by any particular legislature. What this amendment would do would be to constitutionalize that policy so that if we were not holding up our end of the bargain with regard to the environmental rights of the people of this state, the people of the state would be able to seek redress through the courts to you.
Thank you very much, Mr. Chairman. Are you also arguing that somehow this does not create a cause of action between citizens? Because I think by virtue of creating a right out of whole cloth by creating this amendment saying each person shall have an individual right to clean and healthy air, water, soil, ecosystems, environment, and a safe and healthy, stable climate for the benefit of public health, safety, and the general welfare. I think when you say that, you have guaranteed that right. And if anyone infringes upon it, now there is a responsibility for the state to act. But I think that you've also created an avenue for someone to sue their neighbor because they're violating your rights. Just like if someone violated any one of your other rights, you'd have the cause of action to hold them to account if they tried to deprive you of your safety and security, as in the Fourth Amendment, for example, or they muzzled you or prevented you from speaking. You'd have a cause of action against them. Are you suggesting that that cause of action, citizen to citizen, is not created by this proposed amendment?
To you, Senator, yes. My understanding of constitutional rights generally, or actions on constitutional rights generally, and in this case would be that they generally require state action. I don't believe that this amendment would change any of that. There may be other rights of action that this may inform. For instance, if you wanted to sue your neighbor over some environmental violation currently, you could bring what's called a public nuisance action or a private nuisance action, depending on the state. It will depend what provisions apply or what standards apply. And I don't profess to be an expert on public nuisance or private nuisance law, but those laws already exist. So they may be informed somewhat by the jurisprudence that develops out of this amendment, but they would not create those rights. Those rights already exist to you.
Thank you very much. When you say that they will inform those rights, I think what you're doing is changing the standard which currently exists. The standard that we have now is whatever policy is in law. You know, whatever this General Assembly has produced as far as policy regarding environmental standards is the standard by which you would be judged citizen to citizen, whether or not your neighbor's violating the law that we've already created. You're changing that standard with this constitutional amendment. If that constitutional amendment is passed as it is, the standard now becomes that every person has an individual right to clean and healthy air and so on. And when that happens, I think that now you've not only created a cause of action against the state, as you mentioned, for failure to provide that right by enforcing whatever action was necessary to prohibit the offending action from occurring, you've also created a new and higher standard for neighbors to live by as well. I mentioned frivolous lawsuits, partly because of this conversation. I noticed that when we did this similar bill last year, the fiscal note was almost non-existent. It was said something like $10,000, presumably for the cost of doing the ballot question. But I noticed that in other states where similar laws have been debated and or passed, they've had fiscal notes that are remarkably different. I have the fiscal note from the state of New Mexico, which has a very similar proposal. And this is just from earlier this year. This is from February 2nd of 2025 fiscal impact report. And if you read their resolution, it basically says almost the same thing. The people of the state shall have a right to clean and healthy air, water, soil, environments, blah, blah, blah. They don't even say stable climate in theirs, by the way. I'll just leave that as a point of, worth making. This fiscal note, though, shows millions of dollars regarding corrective actions. And I don't think that even encompasses the amount that would be included for legal defense, for example, because that's something that is going to be automatic if this happens. People will sue the state of Connecticut, as they have in every other state where this has similar legislation has passed. Will all of those lawsuits come to fruition and cause a payment by the state? Certainly no. And I know that in some places, I think it's the state of Pennsylvania, where they've had a similar law for a number of years. They're actually going back now and overturning a lot of case law that they have made in the past, because they realized that they opened a can of worms, and now they have the potential that there are going to be many, many other lawsuits going forward. I'm just monitoring New York, for example. I track the cases that have happened there. And again, some of them were dismissed. Some are still in process. Some may take many years to be resolved. But in the process of all of this, case law is being created. And as I mentioned from the outset, what's going on is the decision on what the standard is changing. And it's not being changed by the will of the people, which is what we represent as lawmakers. The will of the people come to the legislature, which is the branch that makes our laws and creates those standards. That's not happening. That standard is now been established in very, very strict, but still vague terms. Strict in the sense that it is a guaranteed right that every person must have these things, but then vague in the sense that the state's responsibility is to not unreasonably infringe upon those rights. And the determination of what unreasonably means is being left to courts. And I just think that is, as I mentioned, a failure on our part. So I have a question, Mr. Chairman. Is the intent for this amendment to be self-executing, or is it going to require implementing legislation?
To you, Senator, the intent would be for it to be self-executing to you.
Thank you very much, Mr. Chairman. Is it intended that this constitutional amendment shall be applied retroactively?
The strong default rule in our jurisprudence is that laws should not be applied retroactively unless it specifically says so in the law. This law does not. So it would be not retrospective, but prospective only to you.
Thank you very much, Mr. Chairman. That goes back to my question about rights and where they come from. Is it your argument then that the right to clean and healthy air, water, soil, ecosystems, and environment, and a safe and health stable climate for the benefit, et cetera, does not exist currently and won't exist until this constitutional amendment is passed?
To you, Senator, now we get into the legal philosophy discussion. I would argue, or some might argue, that a right already exists, but this would officially have the government of the state of Connecticut recognizing it in a way that's cognizable to you.
Thank you very much, Mr. Chairman. I always appreciate your legal opinion as a member of the bar and a skilled attorney, no doubt. But at the end of the day, it's just your opinion. And, judges have different opinions. We all know that. And, it goes back to my fear, which I keep repeating over and over again, is that we are ultimately empowering a judge to randomly make determinations based on what we provide them in the form of this constitutional amendment. And I think there was so much effort in the way this is written to fully endorse the idea that people should have these things, that you're giving, relatively little wiggle room to a judge to say that you didn't mean it. I think that's a concern. If you're going to write policy that has some sort of other intent beyond being good public policy, like it's going to make a political statement or it's going to signal your virtue as a defender of the environment, that's fine. But I think when you do it, you have to be abundantly careful that you are not creating a situation that is going to guarantee a future outcome. Can I ask a question, Mr. Chairman? Are there laws already on the books in Connecticut that affect our environment, or anything else for that matter, that this might end up overturning through you?
To you, Senator, no.
Mr. Chairman, can you just say that, or do you have to say that's my opinion through you?
To you, Senator, this amendment would be prospective, which means that it would be applicable to all laws that come after it and would incorporate by reference all laws that have come before to you.
Mr. Chairman, are we talking about your opinion, or are we talking about a statement of objective fact? Because I believe that the creation of this constitutional amendment will be used to measure against existing law. I mean, how can a court have this adopted as part of our Constitution, and then someone comes before the court and says, they're trying to put a new landfill in down the street from me, and that is in direct conflict with my right to clean and healthy air and so forth? I don't understand how you can suggest that that person wouldn't have standing and a legitimate case for a good result. And the reason why I bring that up is in the state of Pennsylvania, the Supreme Court revived their environmental amendments similar to this one, and they basically blocked projects and overturned laws passed by the legislature because they felt they were in conflict with that environmental amendment.
I'll attempt to respond to the good senator's question. I think just to clarify my previous answer and hopefully to respond to his statement and question, there may be outcomes that under current law that might have happened now, that might not happen in the future if this amendment is passed. But it would not overturn any existing laws. And one of the things that is part of the intent of this amendment was to work with the State Attorney General's office, which enforces the Connecticut Environmental Policy Act, to ensure that the wiggle room is in the amendment so that projects or provisions in the future are not unreasonably restricted. Everything that we do as human beings, as a government, as a society, has some sort of environmental impact. But it's incumbent under this amendment and under our state's current environmental law for the state not to unreasonably infringe upon these rights or unreasonably allow the degradation, diminution, or depletion of the natural environment. And this would constitutionalize those protections. To you.
Thank you very much, Mr. Chairman. Can you, based on your response, can you tell me for sure, and I'm bringing this up because when we debated a similar proposal last year, this was something we bounced around a lot, the notion of gas-powered vehicles and gas-powered appliances and snow blowers and lawnmowers and leaf blowers, et cetera. When we talk about those things, I believe that someone could easily interpret this constitutional amendment to make those things a violation of their right that's been established. If it says each person shall have an individual right to clean and healthy air, and their neighbor is using a gas-powered lawnmower, and they can point to science that indicates that breathing carbon monoxide and hydrocarbons being emitted by that lawnmower are harmful to their health, then how does it limit their ability to make the case that that neighbor at the very least shouldn't be allowed to operate their lawnmower, or that no one should be allowed to operate a lawnmower in the state of Connecticut, much less a vehicle? Through you.
To you, the key word here, first of all, is reasonably. So I think it would depend on the circumstances. First of all, as I noted before, I don't think that this would create any action against one's neighbor in a private capacity. It would create a potential action against the state for failure to sufficiently regulate gas-powered lawnmowers or leaf blowers. I'm not sure which device the good senator was referring to. But I think it would depend on the circumstances. So in the current status, it would be tremendously expensive to immediately transition to all non-gas powered lawnmowers or leaf blowers. But in the future, given the advent of new technology and manufacturing processes, it may be much, much easier to use a non-gas powered mower. And so it would depend on the facts on the ground, on the science, on the technology, on the manufacturing processes to determine what would be reasonable. And I would say that currently it certainly would not be unreasonable to use a gas powered mower, but at some point in the future, it may be.
I appreciate that answer, Mr. Chairman. Again, I just want to remind anyone listening that you're operating on your opinion of the circumstances. The fact of the matter is that someone will decide what the word unreasonably means. And because it's not the people in this room or the legislature at large and will ultimately be decided in a courtroom, we cannot predict what they will decide. What if we have a judge that is an environmental activist? Maybe there's someone who absolutely is against gas-powered vehicles. They drive an electric car. They are offended by the existence of fossil fuels. What if that's the judge that's making the decision? That's a realistic possibility. And in my view, the ultimate danger in such a policy by removing the voice of the citizens of Connecticut and replacing them with an arbitrary judge, an actual judge. We had a lot of testimony submitted on this bill, and the entire business community is up in arms and scared. I mean, I would just say that, like, you're freaking out municipalities and you're freaking out businesses with this bill. I think that's pretty clear from their testimony. And I think that should be taken into account that their opinions are similar to mine, Mr. Chairman. And again, I'm not a lawyer like you, but I do believe that our opinions are somewhat valid by reading the plain language of what's in front of us and having, at least a basic, layman's understanding of, the impact on legislation and how it works and how the court interprets laws down the road. I don't think it's a stretch by any means to say that this amendment might prevent a landfill from ever being created in the state of Connecticut ever again. It could cause a cause of action merely for someone cutting down a single tree, in my view. I think it's highly dangerous to go down this road in such an unclear way. And I don't see a net benefit. Can I just ask that as a final question, Mr. Chairman, and then I'll wrap up? What is the net benefit of this if we are all good people in the legislature, regardless of party, serving our communities, taking the input from our constituents all across the fruited plain of Connecticut, who clearly want to live in a clean and fruitful environment? What is the net benefit of taking away our ability to be the determiners, is that a word, of policy, and transferring the standard, as I mentioned, to a courtroom through you?
To you, Senator. Well, first of all, I applaud and embrace the good senator's endorsement of us all as supporting the environment and environmental protection in this legislature. But suffice to say, the legislature's members may not be always as virtuous as we. And so what constitutional protections do is they establish rights that should exist in the long term, perhaps even in perpetuity, rights that adhere to the residents and citizens of a state, no matter their status, no matter how unpopular they may be, no matter the conflicting winds, as long as, again, in this case, the protection is reasonable. So to put it shortly and plainly, it would establish these rights and the protections that exist under our law for our environment, for our clean air, water, soil, and protection of a stable and safe climate for the long term, regardless of the composition of the legislature. To you.
Thank you very much, Mr. Chairman. And again, I cannot foresee the future any more than you can. And I would just bet on the 187 or possibly more or less future members of this august body to make a determination over what is an appropriate standard for a clean and healthy environment and so on, versus a single arbiter in the form of a judge determining what the policy of the state will be going forward when he is forced, or she is forced, to make a determination based on having this amendment before them. I think that other states are proving to us that this is ill-advised, that we already have a mechanism, the best mechanism that there is for making policy, the tried and true notion of representative government, which presumably every person who's elected around this table or this room, agrees with. We chose to become lawmakers because we trust in the idea of representative government, that this is the system that comes up with the best result. We don't want a tyrannical autocracy. We don't want a monarch. We don't want to have a committee. I know that there are probably some folks that would prefer to have a series of bureaucratic experts making a lot of decisions at our direction. But we've come to this conclusion that this is the system that governs best. And I believe that when you are pushing the decisions of what a stable climate is off on someone else, whether it's a bureaucracy or a court, or whether you're pushing off the decision of what's reasonable or unreasonable off in the same way, you are neglecting your responsibility of writing a clear policy. And I think that if anyone goes through this conversation that we've had, and I appreciate the good chairman for his commentary and his good natured, way of discussing this with me. I think that if you go back and watch it, you're going to come up with that void for vagueness comment I made earlier, ringing repeatedly in your mind, because I think that's what we have here. We have a situation where vagueness will rule the day, and that's no way for us to govern. I understand the desire of many of the folks that submitted testimony in favor of this policy also. And it's nothing but regretful for me that I am going to vote no on this, because I see the world much as they do. I read their testimony and am completely in agreement that we should live in a clean environment, that we should have even more protocols and protections in place to prevent, people that would harm our environment or do evil things like dump chemicals in our rivers and in the ocean and so forth. No one is more interested in those protections than me. Long ago, when I graduated from high school, I wanted to be a scientist. I wanted to be a marine biologist. I mean, I love the environment, and to this day, the outdoors is where I find the most joy. And I certainly want to make sure that that exists long into the future for future generations. Hopefully, my own children at some point. But the idea that we are going to negate the will of the people in making that policy by making this arbitrary, and frankly, I said it earlier, but to me, this is nothing but virtue signaling. It is not good public policy, and it's no way for us to operate. We shouldn't also be changing the Constitution on every other, committee meeting. This committee has multiple constitutional amendments like every year. I don't know that that's something that has happened over the generations that the state of Connecticut legislature has existed. And with that, Mr. Chairman, I guess I'll conclude my remarks today. I thank you for your indulgence. And I hope that at least some of my comments are worth keeping informed with the future language and outcome of this bill. I really don't want to have to debate it in the Senate, but I am absolutely prepared to if necessary. Thank you.
Thank you, Senator. Further comment from the committee? Representative Menapace.
Hi, I just had a quick comment on that. I will keep it very short. But I'm a civics teacher. I've been a civics teacher for over a decade, and I'm very glad to hear our colleagues are opposed to monarchy. I think it's a very good thing to be opposed to. Every part of our state and our national constitution is open interpretation. That's something I teach every day at school here for the last 10 years, well, 12 years, I guess. So that's how our judicial system, it's what it's supposed to do. Yeah, I think the idea that we shouldn't affirm the right to a clean environment just because someone might sue is like saying we shouldn't have free speech because someone might challenge it in court. And I'm sure if our good senator was there, he would have informed the writers of the Bill of Rights and the Constitution that it was just virtue signaling and they should, stick to this one. But we didn't let fear stop us.
Point of order, Mr. Chairman. I just want to remind us that we're not supposed to bring up intent.
I have no idea what he's talking about. I'm sorry.
All right, why don't we just, for a moment, I will just administer. Senator Sampson has raised a point of order. I believe that Representative Menapace is talking about his own reasons for supporting this resolution. And as a general matter, I'll just say that we try to confine our arguments and questions to the bill in front of us. And I would ask that the representative continue with his argument.
All I wanted to say is that I think we didn't let fear stop us from being able to establish the right to free speech when we wrote the Constitution and we had the Bill of Rights. So I don't think we should let that dictate what we do right now.
Thank you, Representative. Further comment from the committee? Representative Shannon.
Thank you, Mr. Chairman. Yeah, thank you. So I just want to say I am going to be voting in support today. I come from a coastal community, and in my lifetime, I have seen how environmental issues have impact our communities, erosion's getting worse, flooding is becoming more frequent. And we do have some really great environmental laws in our state, but it would be great to codify them and make sure that no matter who is in office, we do have these rights protected. And it's also about fairness. So environmental harm doesn't always impact everyone equally. There are environmental justice communities that are low-income communities and communities of color that are really hit hard by pollution and climate change. And they're not always stood up for in these fights, and they can't always afford to go to court and fight for themselves. So we should be keeping that in mind when we're thinking about this. And I think it's always important that we just remember that amendments to our Constitution do go to the people of the state for a vote. It's not just us making the decision today or later down the road in the chambers. It will be up on the ballot for the people of Connecticut to decide as well. Thank you.
Thank you, Representative. Further comment from the committee, Representative Master-Francesco.
Thank you, Mr. Chairman. I will be brief. I just had a couple questions. I do agree with my good ranking member to the side of me here. I think he pretty much touched on everything that was actually on my mind. The language that we see before us today, where it talks about safe and stable climate, is very, very broad language. And I truly believe that when we're writing laws, that the language has to be precise and people need to know exactly what it does. It has to be clear to the courts. And when I was doing my research, I did notice that there's other states that have this: Montana, New York, Pennsylvania. They are under attack. There are a lot of lawsuits because the language is so broad in there. Mr. Chairman, as Senator Sampson mentioned, in Pennsylvania, they did have a lawsuit there, and actually the judge did block projects and overturn laws. And if I remember correctly, in your debate with Senator Sampson, can you confirm to me that the language in here and what we see before us today would not give a judge an authority to block any projects or any existing laws that we have here right now? I think Connecticut currently does have very strong environmental laws. We all want clean air and a clear environment. They are very strong as they are today. But can you tell me, based on the language before us, can a judge overturn our laws? Can you guarantee that that can't happen? To you, Mr. Chairman.
To you, Representative, the intent of this amendment is to constitutionalize our current protections under statutory law. So to answer your question, it wouldn't overturn any of our current laws, but it could result in projects that would be prevented from going forward under our current laws from going forward. To you.
Okay, thank you, Mr. Chairman. So because our language is very similar to the one that has in Pennsylvania, and the Supreme Court actually did overturn the laws in Pennsylvania. So, right, there's no guarantee. Yes, this possibly could happen in Connecticut. Laws could be overturned. What I'm trying to figure out, based on what your analogy is of what the intent is here, is that can we guarantee that that won't happen here? I guess I'm looking for a guarantee, which I don't think you're going to be able to provide. I know it's a far-reaching question, but there are no guarantees. Am I correct to say that, Mr. Chairman?
In life, I think it's fairly well established that there are no guarantees. And so I cannot make any guarantees as a matter of a general principle to the good representative. I will note that although some of the language in our proposed amendment is similar to that in the Pennsylvania one, we also have some language that's not in there, especially in relation to the requirement that the state not unreasonably impair these rights, which does not appear to exist in the Pennsylvania provision. To you.
Thank you, Mr. Chairman. I would disagree with you on one thing, that where you said that there are no guarantees in life. And my mother always just said death and taxes, those are guaranteed. So I will disagree with you on that one.
I stand corrected.
Thank you, Mr. Chairman. Oh, God. It's nice that we can have a little sense of humor when we're discussing serious language like this that could affect everybody in the state of Connecticut. And this absolutely does. I think Senator Sampson is correct. I think it does bring up a lot of cause of action. And to the good representative's comments before, saying that, yes, we have a lot of flooding, putting this language in there is not going to change that. Unless there was a cause of action. There would have to be a cause of action to have any environmental effect on this state. Putting this language in there is just language, but there has to be a cause of action or something to happen to change anything. I don't know if you want to comment on that. Do you agree with me or?
I would agree that someone needs a right of action to access the courts in order to enforce this or any other provision in our laws. I believe that answers the good representative's question to you.
Thank you. Yes. There may be communities that are, maybe their climate in the certain communities are not as good as the climates in other communities. But again, I guess putting this language in here is not going to change any of that unless, again, I'll repeat it, a cause of action. I did have one more question. Mr. Chairman, let's see if I can find it. I had it written down here. Oh yeah, on the lines 7, 8, 9, 10 in the bill, it talks about safety and the general welfare. When you talk about general welfare, exactly, what do we mean by that? It says, the section on line 7. Actually, it's on line 9.
General welfare is a term describing the well-being of the population of the state of Connecticut to you.
Thank you, Mr. Chairman. And what is that? I guess, this is where the judge comes in. They try to interpret the law. When you're talking about our Constitution, I think it has to be exact and it has to be precise so they don't interpret it to what maybe they think it is. So I guess I'm trying to figure out what is general welfare to you?
General welfare embodies a number of concepts, including health and safety, which is already listed previously, but the enjoyment of the environment would be included, the ability of people to work and profitably exist in the environment. These are the concept of the general welfare is a fundamental concept that exists in the preamble of the Constitution, I believe, maybe in the Declaration of Independence. It's been a broad term that's been embodied in our law since the founding of the nation. To you.
Thank you, Mr. Chairman. And again, very broad language. Is any of this determined based on science? We always talk about science, right? It's all about science. Where's the science here? I guess I'm just trying to figure out to you, Mr. Chairman.
To you, the science would be introduced in any proceeding under this amendment in court through experts or through expert testimony or other admissible evidence to you.
We talk about science a lot here, maybe not in this committee, but maybe in our public health committee. And there's different opinions on science. Some people say, look what happened with COVID, right? Was it based on science? Was it not based on science? The treatment for COVID and so forth. Again, it could be interpreted as an opinion or maybe just their research on what they're looking at the time and maybe not diving into it further. Mr. Chairman, if I was cooking out in my backyard on my barbecue grill, and let's say it was a propane grill, a gas-powered barbecue grill, and I'm cooking hamburgers, and my neighbors smell that great smell of my hamburgers cooking, and they're complaining because my gas grill is, it's too smoky. There's too much grease on those hamburgers. It's ruining the environment for them. It's ruining their backyard. Would that be considered, could that be a cause of action to you, Mr. Chairman?
To you, I don't believe it would be a cause of action that would exist. Well, I don't think it would be recognized under our current law, but it certainly would not be newly recognized under this amendment to you.
Thank you, Mr. Chairman, but it would violate someone's individual right to a clean and healthy air. Would you agree with that?
I disagree that your delicious hamburgers would violate your neighbor's right to clean and healthy air. And in any event, this amendment would not create a private right of action between individuals, but rather against the state to you.
Thank you, Mr. Chairman. And I don't mean to make light of it. I'm just using that as an example of as where someone could actually take you to court because you're constantly, you have one of those fire pits in your yard. People burn their fire pits in their yard and the air smells. I have a neighbor that's constantly burning and sometimes I gotta keep my windows down. So I could actually file a suit against them that they are violating my environmental constitutional right to clean air. So my point is that, yes, those things could happen and we cannot guarantee that it won't happen because as we have seen in other states, there have been plenty of lawsuits filed. And again, it's not about, well, I guess I'll just leave it at there, Mr. Chairman. I think this is very broad. I think the environmental policies that we have here in Connecticut today are very good. I think they're working absolutely just fine. This is just way too broad. It's just going to open up a can of worms. I mean, just think about even people putting buildings up, businesses that it would affect, the amount of lawsuits. And you know what? It is about lawsuits. Because at the end of the day, that's the only way things sometimes are settled is through the courts. That's just the way it is. So I appreciate the intent. I'm obviously not going to be supporting this today. And that's it, Mr. Chairman. Thank you.
Thank you, Representative. Further questions or comment from the committee? Seeing none, oh, sure. I was just going to make one more comment in response to some of the points raised by, I believe it was the good senator, with regard to the power that would be allotted to the court compared to the legislature. And certainly passing an amendment like this would provide more power to the courts to hold us accountable in our commitment to preserving and protecting the environment for the people of Connecticut. But it would not be the end of the story to say that a decision by a court would mandate what would happen next, as we've seen in the Sheff versus O'Neill decision over several decades, as it's been implemented, which was a decision finding that the state was failing in its implementation of the right to education in the state. There was recurring conversation between the courts and the state to implement settlements on which the legislature, the General Assembly, passed bills to provide for measures that would help better implement that right and make sure that every student in the state received their right to education. Certainly, I think many would disagree that those settlements or the bills we've passed have fully guaranteed that right, but it is not the end of the story or the end of the conversation. When a court speaks, we will always have the right to respond and to implement those decisions through what we view as the best means. And with that, I will pass to my co-chair, who also has a comment to you.
Thank you, Mr. Chair. I just wanted to give some brief comments in support of the resolution, but I actually think I will make my starting point from what you were just talking about with our state's constitutional protections of a right to education. I would argue that, frankly, this General Assembly would not be as aggressive as it has been when it comes to protecting the right to an education in our state if it weren't for those provisions in our state constitution. And it's a debate for another committee, but I think in many areas we're still failing in that regard. And people are able to come to the table and argue for better because of the rights that are protected in our state's constitution. And that's why this resolution before us here today is so important. We've had some spirited debate. And as others have said, I'm grateful to hear that, we all agree that protecting our environment and everyone's right to a clean and healthy environment is an important one and something we want to protect here in our great state of Connecticut. But for many of us, and particularly in these weeks and months, the things that were always a guaranteed fact in so many areas of our lives feel like they're changing underneath our feet. And when Representative Menapace was speaking earlier about his experience as a civics teacher, it reminded me of why I'm so passionate about this resolution and so grateful to the advocates and the coalition that have come together to try to move this change to our state's constitution. It's because young people in our state are, in a variety of ways, seeing a world that is less and less than the world that were given to their parents and their grandparents. And when it comes to our environment, perhaps that statement is the most true when it comes to our environment. When I think about the young people who are growing up here in our state and in our country and in this world, our environment is changing rapidly, and we need to do everything we can to protect it. Each and every year here in our state and across this country and across the world, we are seeing the effects of climate change and natural disasters and the lives that are lost, the property that is damaged, and this change is causing unbelievable harm to so many people. And we have a responsibility as elected officials to do everything we can to try to advance policies to mitigate that. And that's why putting this Environmental Rights Act in our state's constitution is so important, so that in the future, if this legislature changes as drastically as we've seen other elected bodies change in this country, we can have some solace in the fact that a right to a clean environment is going to be protected, and that policies here in the state of Connecticut that our state enacts are going to be viewed with the lens that ensures that the health and safety and the environment of our state is first and foremost in any decisions that are made. So I'm hopeful that members of this committee will choose to support this resolution here today, and I'm hopeful we'll be able to send this to the people of the state of Connecticut for their approval in the future as well. Thank you, Mr. Chair.
Thank you, Madam Chair. Further comment or question from the committee? Seeing none, Mr. Clerk, would you please call the roll?
This is a roll call vote on item number four, Senate Joint Resolution number 36, resolution proposing a state constitutional amendment concerning environmental rights. The motion is to JFS LCO number 6720 to the floor. Senator Flexer,
Yes.
Representative Blumenthal,
Yes.
Senator Honig,
Yes.
Representative Morin-Bello,
Yes.
Representative Osborne,
Yes.
Senator Sampson,
Sam says no.
Representative Master Francesco,
No.
Representative Bronco, Representative Carpino,
No.
Representative Fonsello,
No.
Representative Gauthier,
Representative Gauthier, yes.
Representative Haddad, Representative Hoxa,
Rep. Hoxa no.
Representative Johnson,
Representative Johnson votes yes.
Representative Menapace,
Yes.
Representative Rosario, Representative Santiago,
yes,
Representative Shannon,
Shannon votes yes.
Senator Winfield. Thank you, Madam Chair.
Thank you, Mr. Clerk. And I think now would be an appropriate time to adjust when our votes are being held open until. The votes in this committee will be held open until this committee recesses at least half an hour after this committee recesses. And we'll adjust that time going forward as necessary. Next, we have House Bill 5422, an act reestablishing the Legislative Program Review and Investigations Committee. The chair would entertain a motion to JF this bill.
So second.
Motion has been made by Senator Honig, seconded by Representative Menapace. This bill has been before us a number of times. It would reestablish the Program Review and Investigations Committee, which was long and important part of the legislative branch's efforts to be able to have oversight of various state agencies and be able to study various policy initiatives. And this bill would restore program review and investigations. Is there any comment or questions from members of the committee? Representative Master Francesco.
Thank you, Madam Chair. Yeah, I know we've had this bill in our committee before. It's been a work in progress. It's a good bill, and I think it should pass. So I urge my colleagues to support it.
Thank you, Representative. Any further comments? Seeing none, Mr. Clerk, will you please call the roll?
This is a roll call vote for item number 5, House Bill 5422, an act reestablishing the Legislative Program Review and Investigations Committee. The motion is to JF it to the floor. Senator Flexer,
Yes.
Representative Blumenthal, Senator Honig,
Yes.
Representative Morin-Bello,
Yes.
Representative Osborne,
Yes.
Senator Sampson,
Sampson is yes.
Representative Master Francesco,
Yes.
Representative Bronco, Representative Carpino,
Carpino votes yes.
Representative Fonsello,
Yes.
Representative Gauthier,
Yes.
Representative Haddad, Representative Hoxa,
Cox is yes.
Representative Johnson,
Representative Johnson votes yes.
Representative Menapace,
Yes.
Representative Rosario, Representative Santiago,
Yes.
Representative Shannon,
Shannon votes yes.
Senator Winfield. Thank you, Madam Chair.
Thank you, Mr. Clerk. Moving on, item number 6, House Bill 6040, an act requiring the State Commission on Capital Preservation and Restoration to develop a process for adding statutes to the state capitol and establishing a state historical commission. The chair would entertain a motion to JFS this bill with LCO number 6717. Is there a motion? Motion has been made by Senator Honig, seconded by Representative Morin-Bello. This bill would require the Commission on Capital Preservation and Restoration to develop a process to identify and commission new statutes for our state capitol building and to develop and submit a plan for installing informational signage with historical explanations for various statutes that are on display in the interior and exterior of our capitol building. And markers on the exterior of the building as well. It also establishes a state historical commission to examine and make recommendations to the legislature regarding the memorialization and commemoration related to Connecticut and U.S. history. The JFS language takes feedback that we got at the public hearing. One is from the judicial branch asking that the chief court administrator or their designee be added to the commission and that the state historian be added to the newly created commission. This proposal overall, I believe, comes to us because of some debate that has happened in this legislature in a different committee with regard to statutes that exist at our state capitol, and also with a desire to have a more formal process for how statutes will be added in the future. This is a proposal our committee has looked at, a similar proposal in the past, and I hope that my colleagues will choose to support this bill. Are there any further comments or questions? Seeing none, Mr. Clerk, will you please call the roll?
This is a roll call vote for item number 6, House Bill 6040, an act requiring the State Commission on Capital Preservation and Restoration to develop a process for adding statutes to the state capitol and establishing the State Historical Commission. The motion is to JFS LCO number 6717 to the floor.
You're good.
Oh. Senator Flexer,
Senator Flexer votes yes.
Representative Blumenthal,
Yes.
Senator Honig,
Yes.
Representative Morin-Bello,
Yes.
Representative Osborne,
Yes.
Senator Sampson,
Sampson is no.
Representative Master Francesco,
No.
Representative Bronco, Representative Carpino,
No.
Representative Fonsello,
No.
Representative Gauthier,
Yes.
Representative Haddad, Representative Hoxa,
Rep. Hoxa votes no.
Representative Johnson,
Representative Johnson votes yes.
Representative Menapace,
Yes.
Representative Rosario, Representative Santiago,
Yes.
Representative Shannon,
Shannon votes yes.
Senator Winfield. Thank you, Madam Chair.
Thank you, Mr. Chair. For a moment, we are going to go out of order a little bit, and we are going to go to item number 8, House Bill 7207, an act concerning the disclosure of insurer reports concerning mental health parity as a public record. The chair would entertain a motion to JF this bill. Motion has been made by Representative Blumenthal, seconded by Representative Morin Bello. This proposal before us requires that information the insurance commissioner receives with regard to mental health care be public records under our Freedom of Information Act. Is there discussion on this bill? Seeing none, Mr. Clerk, will you please call the roll on House Bill 7207?
This is a roll call vote on item number 8, House Bill 7207, an act concerning the disclosures of insurer reports concerning mental health parity as a public record. The motion is to JF to the floor. Senator Flexer,
Yes.
Representative Blumenthal,
Yes.
Senator Honig,
Yes.
Representative Morin-Bello,
Yes.
Representative Osborne,
Yes.
Senator Sampson,
Sampson is yes.
Representative Master Francesco,
Yes.
Representative Bronco, Representative Carpino,
Carpino votes yes.
Representative Fonsello,
Yes.
Representative Gauthier,
Yes.
Representative Haddad, Representative Hoxa,
Hoxa's yes.
Representative Johnson,
Representative Johnson votes yes.
Representative Menapace,
Yes.
Representative Rosario, Representative Santiago,
Yeah. Yes.
Representative Shannon,
Shannon votes yes.
Senator Winfield. Thank you, Madam Chair.
Thank you, Mr. Clerk. Next, we will consider item number 9, House Bill 7208, an act concerning referenda on the sale of municipal authorities or other assets or the privatization of municipal department services or functions. The chair would entertain a motion to JFS this bill with LCO number 6729. Motion has been made by Representative Blumenthal, seconded by Representative Morin-Bello. This bill, as we heard last week in public hearing, gives citizens a right to put forward a petition for a referendum if there is a municipal decision to sell an authority or another asset or privatize department services or functions. The JFS language makes changes that were presented during the public hearing. It lowers the threshold for a successful petition from 10% to 5%. As we heard during the public hearing, the notion of getting the signature of 10% of electors in a given community within a 30-day time period is a very high threshold to be able to meet. So this language before us changes that threshold to 5%, but still within that 30 days. It provides for requirements for the petitions, which was not in the underlying bill that we heard last week. And it specifies that the sale agreement cannot be finalized until the 30-day deadline for the petition expires. Are there questions or comments from members of the committee? Representative Master Francesco.
Thank you, Madam Chair. Madam Chair, I listened to the testimony on this and I am in somewhat of an agreement with with the frustration of people in town not being able to challenge their municipality and put a question on the ballot on certain issues. And I certainly understand that frustration. My concern on this bill is really, this is a municipal mandate. And as I said during our public hearing, that if people have an issue with what's going on in their town, they can always go and change their charter. There's a charter revision process, I believe. I don't know if it's 5 or 10 years that has to be done through the town council. They can change their charter to allow for initiative and referenda. Or they have the ballot box. If they don't like what's going on in their town, they can certainly vote their legislative body within their town out of office. So I understand this completely, and I'm very sensitive to it. And I somewhat agree with it, but what I don't like is putting this a mandate on a town and making sure that every town does this. To continue with the theme of my always supporting local control, I would have to oppose this today. Thank you, Madam Chair.
Thank you, Representative. Are there any further comments or questions? Seeing none, Mr. Clerk, will you please call the roll?
This is a roll call vote on item number 9, House Bill 7208, an act concerning referenda on the sale of municipal authorities or other assets or the privatization of municipal department services or functions. The motion is to JFS LCO number 6729 to the floor. Senator Flexer,
Yes.
Representative Blumenthal,
Yes.
Senator Honig,
Yeah.
Representative Morin-Bello,
Yes.
Representative Osborne,
Yes.
Senator Sampson,
Sampson is no.
Representative Master Francesco,
No.
Representative Bronco, Representative Carpino,
No.
Representative Fonsello,
No.
Representative Gauthier,
Gothier, yes.
Representative Haddad, Representative Hoxa,
Hawk says no.
Representative Johnson,
Rep. Johnson votes yes.
Representative Menapace,
Yes.
Representative Rosario, Representative Santiago,
Yes.
Representative Shannon,
Shannon votes yes.
Senator Winfield. Thank you, Madam Chair.
Thank you, Mr. Clerk. Next is item number 10, House Bill 7128, an act concerning the use of online donation platforms for political campaigns. The chair would entertain a motion to JFS this bill with LCO number 6711.
So moved.
Motion has been made by Representative Blumenthal, seconded by Senator Honig. This bill is, with the JFS language, is identical to the second item we acted on today, Senate Bill 1168. It combines the two concepts that were in each of those underlying bills to both expand the fundraising platforms that can be used and also safeguard contributors using any online fundraising platform to limit the number of recurring contributions that can be, to limit an individual contributor from accidentally signing up for a recurring contribution, to make sure that a person has to affirmatively consent to a recurring contribution. I would just add, since I didn't add this to the debate on the previous bill, that I think this is a really important measure, and I'm grateful to have had the opportunity to introduce it in this committee with Representative Haddad for protecting many people who we've seen supporting candidates on both sides of the aisle erroneously signing up for multiple contributions and having at times tens of thousands of dollars unwittingly donated to political candidates and committees. Hopefully this is a good measure to protect people in our state so they won't be harmed by that kind of practice in the future. Are there any comments or additional questions from members of the committee? Seeing none, Mr. Clerk, will you please call the roll?
This is a roll call vote on item number 10, House Bill 7128, an act concerning the use of online donation platforms for political campaigns. The motion is to JFS LCO number 6711 to the floor. Senator Flexer,
Yes.
Representative Blumenthal,
Yes.
Senator Honig,
Yes.
Representative Morin-Bello,
Yes.
Representative Osborne,
Yes.
Senator Sampson,
Sampson is no.
Representative Master Francesco,
No.
Representative Bronco, Representative Carpino,
No.
Representative Fonsello,
No.
Representative Gauthier,
Yes.
Representative Haddad, Representative Hoxa,
Rep. Hawk says no.
Representative Johnson,
Representative Johnson votes yes.
Representative Menapace,
Yes.
Representative Rosario, Representative Santiago,
Yes.
Representative Shannon,
Shannon votes yes.
Senator Winfield. Thank you, Madam Chair.
Thank you, Mr. Clerk. At this time, that will conclude our business for today. This committee will be in recess until 5:45 so that members can cast any votes they may have missed. I know there are a number of different committees meeting and having public hearings right now. So we thank everyone for their time and attention today, and we look forward to seeing you on Friday and Monday and Wednesday and Friday. Thank you very much.
How are you, Representative Murphy?
I did see that. Yeah, I have.
Sorry about that. How's it going, Representative Carpino?
Great, no problem.
All right, so I need your vote on SB 1163, the first one.
I think we might be able to.
Like to vote yes?
Second one, 1168.
No?
All right. The third one, 1499.
No.
I think that's it, but let me just double check.
Sure was number 7.
Number 7 we held, so they put that.
Perfect.
Yep, that should be everything. Thank you so much.
Thank you.
How are you, Representative Hoxa?
Hi, Murray. Good. How are you?
Good. I think it was just one vote I missed, Joe. Let me double check. Yes, so for number 3, 1499, how would you like to vote?
Is that the contract review?
Yeah,
bullet?
the contracting standards for?
Yeah, no for
Okay.
that.
No for that?
Yes.
Let me just double check. All right. Yep, that's all I need. Thank you so much.
Thank you, sir. Have a good one.
You too.
Bye.
Yeah,
Good afternoon, Representative. Murray's gonna take over.
Can you hear me?
Yep, I can hear you now.
Okay.
All right, so I have 1163 for you, the first item.
Yeah, you're gonna have to help me. My
Sure.
agenda with my votes is in my pocket.
So that's the individuals appointed to serve as moderators at elections and primaries.
How was Gail on that one?
That was a yes for Gail.
Okay, yeah, yes.
Okay. All right, and then it should be the Program Review and Investigations Committee 5422.
Believe that's a no.
Okay.
Was that Gail's no there?
Gail was a yes on that one.
Oh, okay, then yes. So if it make it easier, I had all the same votes as Gail on my sheet. So
Okay.
So that was a yes.
Yeah, then 6040, that's the state capital preservation. She voted no on that one.
Yeah, I'm a no there.
Okay. Then I have the mental health parity 7207. That was a yes for her.
Yeah, I'm a yes there.
All right. And then 7208 municipal authorities and privatization one. She voted no on that.
I'm a no there.
All right. And then the last one, 7218, the online donation platforms for political campaigns. She voted no on that.
Yeah, and I'm a no on that one too.
And then just so you know, we held item number 7, which was 7206, just so you're aware, which was the
okay. Okay, yeah, appreciate that.
All right, thank you. I have all your votes.
Thank you.
Have a good one.
You too. Hello.
How's it going, Representative Rosario? I'll be with you in 1 minute.
Thank you.
How's it going, Representative Rosario?
Hi, how are you?
Good. Sorry about that. All right.
No
So
problem.
do you have the agenda with you?
I don't actually. I'm sorry.
No, it's all good. All right. So I need your vote for number 1, which was 1163. That's the moderators at elections and primaries.
In the affirmative.
All right. Number 2, 1168. That's the online political fundraising platforms, recurring contributions one.
In the affirmative.
Number 3, which was 1499, state contracting standards board review recommendations.
In the affirmative.
All right, thank you. Number 4, SJ 36, the constitutional amendment for environmental rights.
In the affirmative.
HB 5422, Program Review and Investigations Committee, that's number 5.
In the affirmative?
Right. Then, HB 6040, number 6, that's the State Commission Capital Preservation one.
In the affirmative?
Representative, we need your vote on one item. It was 5422 you looked at.
Oh, sorry, I'm a yes.
Okay, good, thank you.
What is that one?
All right, and then item number 7, which that was the siting council one. That one we held. Just so you know.
Okay.
So the next one will be number 8, which is HB 7207. That's the disclosure of insurer reports, mental health parity.
In the affirmative?
All right. Next one, number 9, 7208, referendum sale municipal authority one, the privatization.
In the affirmative?
And then the last one, 7128, online donation platform for local campaigns.
Also in the affirmative.
All right. Thank you so much. That's all I
Thank
need.
you. Thank you for your patience. Have a good
Thank
evening.
you. You too.
Okay.